Hi, I'm Ashley, an estate planning attorney at SJF Law Group in Plantation, Florida. Let's picture a safety net, a big one, stretched under everything valuable you own. That's what a good estate plan is for your family, but even the best safety nets have small gaps. Here's one of those gaps in Florida. You go to the hard work of setting up a living trust. You move your house, your bank accounts, and your investments into the trust. It looks solid. But what if something slips through? Maybe you purchase a new home in your individual name. Maybe a savings account stays in your name, not the trust's. This is where a pour-over will steps in. Think of it like a broom that sweeps up those stray assets and pours them back into your trust after you're gone. Let's walk through why we need both a trust and a pour-over will in Florida and how these tools work together. Wills versus trusts. People ask about this all the time. Are they the same? No, they work differently. Start with a will. A will is a set of written instructions to the probate court. Probate is a legal process the court uses to transfer things you owned in your name when you die. In Florida, even if the process is simple, probate costs money, takes months, and the court makes details about your estate part of the public record. A trust is different. Think of a trust as a locked treasure chest. You put your valuables inside while you're alive. You pick a trustee, someone you trust to manage the chest. When you pass away, the trustee follows the trust instructions and hands out what's inside to your chosen people. No court required, no public details. It's quick and private. Many people think, if I make a trust, I'm set. I don't need a will. But here's the secret. Even the best treasure chest leaks if things get left outside. If you forget to put something in the trust, a house, a last-minute bank account, or a check made out to you, those assets sit outside the chest. On your passing, those things have to go through probate. Here's where our broom, the pour-over will, comes in. A pour-over will is a simple type of will that says, if I leave anything out of my trust by accident or on purpose, I want it to go into my trust after I die. The court reads the will, transfers those assets to your trust, then the trust shares those with your loved ones under your trust rules. Let's use a lemonade stand analogy. Imagine your trust is a secure bank to hold lemonade earnings, and your pour-over will is a rule you leave with your family. Any money I put in the cash jar at home that isn't in the bank account yet goes straight to the bank when I'm gone. The court, probate, still needs to step in for that cash jar. But instead of your family arguing or guessing about where it goes, the will swoops in and puts it where you planned. Why is this important in Florida? 1. Accidents happen. People forget to put assets into their trust. Some things, such as legal settlements, insurance checks, or last-minute inheritances, come after you set up your plan. 2. Avoid mistakes. If you don't have a pour-over will, assets outside the trust pass under Florida's default rules. That might leave things to the wrong people or make your plan much messier. 3. Simpler process for your family. The pour-over will clears up questions. It points a big arrow. Send these things to my trust. Some people ask, isn't the goal to avoid probate? Yes, that's the trust's job. A pour-over will catches the leftovers. Those leftovers still stop in probate, but only once. Then, the will sweeps them to your trust. From there, the trust rules take over, ensuring your wishes get followed, even for those stray items. Here's a common myth. If I have a trust, I never need probate or wills. The truth? You should double-check that every major asset you want out of probate is retitled in the trust's name or has a direct beneficiary named. For assets that slip through, probate happens, but the pour-over will cut down on confusion and family arguments. Let's walk through a story. Sam creates a living trust and puts his house into the trust. He forgets about a small bank account he opened years ago. Sam passes away. His trustee finds the forgotten account. Because Sam signed a pour-over will, the probate court moves that money into the trust. Then, Sam's trustee follows Sam's instructions in the trust and disperses the money. Sam's plan works, even though something was overlooked. Without a pour-over will, that bank account gets stuck. Florida's default laws decide where it goes, which can be very different from what Sam wanted. Maybe it ends up with distant relatives or causes delays. So, to sum up, every trust needs a backup plan, a pour-over will. A trust avoids probate only for things titled in its name or with direct beneficiaries. A pour-over will tells the court to send stray assets you forgot back to your trust. Your plan runs smoothly and your family faces less stress. Setting up a trust is like putting up the strongest safety net. But a pour-over will sew up any holes. They work together to protect your wishes, no matter what surprises life throws your way. If you found this video helpful, please give it a thumbs up. If you haven't already, make sure to subscribe to our channel to be notified whenever we add a new video. Thanks for watching today.